We are on the record and live on YouTube. This is the People versus Henry Russell Johnson, calling case U-569-25020, 1 count of receiving and admitting or accosting and soliciting. Appearances.
Sydney Rogers for the People, P8072.
And Dennis Whitey, P79560. Appearing on behalf of Mr. Johnson, please stand up and state your name for the record.
Henry Russell Johnson.
Good morning to you all.
Good morning.
And it's my understanding that before we begin the trial, that there is a motion to be argued via Walker hearing. Is that correct?
That's correct.
That's correct, Judge. There was actually a two-part motion officially filed just this morning. Of course, I got this case late last week. Ms. Rogers was out of town, and plus with the lack of time to research and try to get a brief together, time was very short, so I do apologize for doing this during the actual trial date. Also, Judge, I spoke to my client for the first time today. We didn't have a phone number on file. I tried to search him through social media over the weekend and try to send him a Facebook message. I just couldn't locate him. But now that he is here, we are ready to proceed with the Walker motion that I filed. And Judge, if the Walker motion is denied, then we would need to move to the second motion, which would require testimony with regard to the corpus delicti issue that I filed before the court.
Okay. And Attorney Rogers, you did have an opportunity to review the motion.
Yeah. Yes, I was able to review it this morning. Defense counsel has given it to me in writing and emailed it to me late last night. I am prepared to proceed today. I'd also like to put on the record that we've talked about off the record that this Walker hearing will have a very limited scope. I don't believe that the stop is being challenged. It is simply these statements alone, if that is correct, counsel?
That is correct, Judge. For purposes of this motion, the defense is not contesting the reasonable suspicion to stop the motor vehicle. Our whole issue was, should Miranda warnings have been issued before questioning? That's the whole issue for this, so this should be very limited in scope. I agree.
Okay. With that, I believe we are ready to begin. So whenever you're ready for your first witness.
Call Corporal Landrum, please.
Yes.
Thank you. You swear affirm that the testimony about you like the truth, told you the truth.
Yes, ma'am.
Okay. Whenever you're ready.
Thank you. Good morning. Could you please state your name and badge number for the record?
Corporal Robert Landrum, badge number 1484.
And how are you employed?
Wayne County Sheriff Special Ops,
And what does it mean to be in special ops?
investigating drugs and prostitution.
And do you have any special training or experience to be able to perform these duties?
Yes, I do.
What is that?
One or two training, seminars, training classes.
And how long have you been a corporal?
Sheriff Department going to 30 years.
And were you on duty on April 6, 2020?
Yes, ma'am.
Okay. And were you in the area of McNichols and John R?
Yes, ma'am.
What brought you to that area?
Investigation, prosecution, and drugs.
And do you often investigate for prostitution and drugs in that area?
Yes, ma'am.
And why is that?
From citizen complaints and private cases.
And when you were at that area, what did you see?
That morning, approximately 7:45 a.m., I drove a burgundy Chrysler van, pulled into a gas station at 6 Mile, McNichols and John R. Then I jerked a known prostitute, Miss Lloyd, and took the passenger side of the wheel.
Okay, and to go back, that's Miss Lloyd. How did you know she's a prostitute?
I've had previous cases with her, probably dating back to 2015.
Okay, and were these prostitution cases?
Yes, ma'am.
And do you work in this area often?
Yes, ma'am.
Do you see Miss Lloyd in this area often?
Yes, ma'am.
All right, and once you saw Miss Lloyd in the car, what happened from there?
The vehicle proceeded out to John R. then travel northbound to Arizona Street, and then continue to go westbound towards, Woodward.
Okay. And I'm sorry, was anyone else in the vehicle?
At the time, I just knew it right.
Okay, so there was someone else in the
Yes,
vehicle?
right.
Was this a male or female?
Man.
Okay. When you followed the vehicle, what happened from there?
Radio was out, 2 other units, vehicle then proceeded up, westbound to Woodward, where it pulled over to the curb and stopped. Followed that out again, I had another unit who was driving by, the vehicle, at which time that other unit observed the store stopping out there.
Were you behind the vehicle when it stopped?
Yes, ma'am.
Did you stop the vehicle?
Yes, ma'am.
Okay, meaning you put lights on, or,
Lights,
okay, so were you conducting a traffic stop at this point?
investigators.
Okay. And the vehicle stopped when you put your lights on?
Yes, it proceeded, northbound over to the next street, which is, Dakota, then it went, eastbound. After activating the lights, it took me a few minutes, a few seconds to stop.
Okay.
Found the vehicle.
And once you stopped the vehicle, what happened from there?
I approached the driver's side. The driver, known as Mr. Johnson, was very loud. He was reaching for his phone. I asked Mr. Johnson to show me his hands. He started immediately saying I didn't do nothing, they pulled me over for nothing. I asked Mr. Johnson, you need to talk to me, so I explained to him what's going on. He was loud, just extremely loud, and just, so I finally asked Mr. Johnson, can you step out the vehicle? He stepped out the vehicle. I asked him who was the prostitute, who was the female with me. Mr. Johnson claimed, I know her. I said, what's her name? He couldn't-
Judge, at this point, I'm sorry, this is getting into the actual statements. The court will be the trier of fact. I think it just relates to the environment. Questioning occurred, Judge. I think that's what, for purposes of this hearing, but I don't think that the witness should be allowed to testify to what actually was stated. Obviously, if this is suppressed, then the court should not be aware of that.
The statements can be stated today, because this is essentially somewhat of an evidentiary hearing, a walker hearing, to see it's all going on what these statements were and how they were conducted. To get a full testimony from the officer, everything needs to be said so the court fully understands what happened that day when they're making their ruling, if these statements were done in a voluntary manner.
Yeah, I'm gonna have to agree with the people on that, with a walker hearing or evidentiary hearing, I'm supposed to be able to hear everything and be able to be impartial if this were a trial and a bench trial to be able to separate what I've heard today.
Thank you, Judge. Okay.
Can you speak up just a little bit louder?
Yes, ma'am.
Okay.
And
I'm
I'll
trying
try
to
to-
Okay.
Okay, so once you stopped the vehicle, you did, upon the initial stop, was the defendant complying with you?
No, not originally, no, he was loud. He was just very loud, and just argumentative.
Okay,
And I was trying to explain to him who we were, what we were stopping him for as far as the, non-prostitute was concerned. And he was just erratic, just loud.
okay. And how do you typically, or how, in this case, did you start the stop? Do you say anything to begin the stop? Do you declare who you are?
Yes, I explained, we definitely explained we are, we're plain clothing, but we wear markings, we have, plain vehicles with police lights and sirens. So I explained to him who we were, and, like I said, he just continued to be argumentative, stating on the phone, whoever he was talking to, he didn't do nothing, the police pulled me over for nothing. I explained to Mr. Johnson, he was trying to talk to me, so I explained to him what was going on. He continued, just, loud, and, then at that point in time, my partner, brought the, Ms. Johnson, who was actually out the vehicle on Arizona Street, she brought her over to the stop.
Okay.
Ms.
Fair enough.
Johnson, did you say?
No, Ms. Lloyd,
Ms. Lloyd.
yes.
Okay, so then once the defendant, or Mr. Johnson, correct? Yes, Johnson got out of the car, what happened from there?
I continued to try to speak to him until, again, once the, Ms. Lloyd actually made the scene. Then Ms. Lloyd actually said out loud, I actually heard her say that he had just gave her $8 for a blowjob, but she didn't do anything because he didn't like the way she was acting, and he was trying to take the money back for her.
And did you ask any questions of Mr. Johnson himself?
At that time, I asked Mr. Johnson, is this true? And he was like, no, I know her. I said, so what she's saying is not true. And then Mr. Johnson instantly said, well, bro, I'm not gonna lie to you. Yeah, I was trying to get a little something, but she was acting crazy. I wanted my money back.
Okay, and can you please identify if the person that made these statements to you is in this courtroom today and something that they're wearing?
Yes, he's wearing a gray t-shirt, black pants.
May the record reflect the defendant has been identified?
Reflected.
Thank you. Okay, and so after he made these statements to you, did you do anything from there?
Oh, yes, I continued, and I explained to Mr. Johnson that the way this young lady was talking, it sounds like he was physically trying to take money from also. Mr. Johnson was like, no, I wasn't trying to do that. I'm not trying to catch a robbery case. And I said, Mr. Johnson, more or less, this is what's happening. I told him he's going to get a ticket, and his vehicle's going to get a prosecution.
Okay. And did you ever place Mr. Johnson under arrest?
No,
Why didn't you place him under arrest?
because he wasn't under this. He was under investigation. He was trying to figure out what's going on, prosecuting his vehicle.
And what's the difference between conducting an investigation and placing someone under arrest?
An investigation person, if they don't want to talk, they don't have to talk. They can leave. If you're under arrest, you're not allowed to.
Okay. And could he, Mr. Johnson, have left in this situation?
If he chose to, yes.
Okay. But if someone's arrested, can they just leave if they want?
No.
And why didn't you make an arrest in this situation?
We had an option as far as like misdemeanor ticket or arrest. And the high option to get a ticket. Accept the arrest.
And did you Mirandize Mr. Johnson?
No, you're not.
Why didn't you Mirandize Mr. Johnson?
Because he was under arrest.
You were only investigating.
Only investigating.
Do you Mirandize when you're just making an investigation?
No.
Is there a reason you do not Mirandize when you're only doing an investigation?
Well, basically, investigation is trying to find out if what you even have a crime. So it wasn't necessary at that point in time for arrest, for Randall.
Okay. So if you're only doing an investigation, it doesn't have to end in arrest, does it?
Correct.
But if you do an arrest, it has to start with an investigation though.
Correct.
Do you ever Mirandize someone when you're simply investigating?
No.
Nothing further. Carl?
Okay, Corporal, was there, just so I'm aware, was there any video or body camera evidence taken?
No, sir.
Okay. Now, moving forward, I would like to just take you right to the stop. I'm going to get right to the heart of the matter, okay? Upon stopping the vehicle, you used your overhead lights, is that right?
We have inside lights inside. We have a windshield inside the wheels.
Okay. And so then Mr. Johnson, my client, pulled over?
Yes, sir.
Okay. And given that, you approached the vehicle, is that correct?
Correct.
Okay. Now, I know you testified he was acting erratic, loud, grabbing the phone. Was he on the phone with anybody?
He did not get on the phone until I was actually walking into the vehicles when I saw him put the phone into his ear.
Okay, gotcha. So, that being the case, once you approached, you asked him to step out at some point, right? So step out of the motor vehicle, correct? Okay. And when you did that, you did place him in handcuffs, right, for your safety?
I don't recall this.
Okay. So it's, you don't recall, so you may have put him in handcuffs, is that correct?
I don't recall this.
Okay. Actually, no. I'll just refresh real quick.
Okay.
Judge, if I could approach the witness, I'd like to, I'm showing you a picture that was part of the file that the prosecutor gave me as a part of discovering this case. Do you recognize this picture?
Yes, I do.
Okay. And looking at that picture, does that help refresh your memory? You see, well, let me step back. You see Mr. Johnson's hands are behind his back, is that correct?
Yes, I do.
Okay. Did anybody handcuff him?
Not that I recall, no.
And did you take this picture?
Pardon me.
Okay. But it's an accurate depiction on that date and time of what was
Yes,
seen?
it is.
Okay. I guess now I'd like to move to admit that, Judge. Defense proposed Exhibit A.
Do you have an objection?
No objection. Oh, and I have 2 copies of.
Oh. Oh, sorry. Now, you testified earlier, I believe on direct, that this was.
I'm sorry, what
Do you want this marked right now, or?
we can do it later, but
I can do it later.
we don't know, we'll take a picture.
Okay.
This was admitted, correct, Judge?
Yes, it was admitted.
Confirmed. Okay. Moving along, you stated that this was an investigative stop, isn't that right? Okay. An investigative stop, you're detaining somebody, correct?
We're talking to someone.
Correct. And so at that point, they're not free to leave, is that correct?
No, that's not correct. We do not want to talk, we do not have to say a thought.
Okay, so when an officer puts his lights on, he was free to just take off and not yield and pull over?
You can do it all the time.
Would you potentially give pursuit or attempt to arrest him?
No, we're not. The crime has not been committed to the point that we can ever prove that. No, we're not.
Now, when you approached them, did you use statements such as, you got caught with your pants down?
No, I didn't.
Okay. Did you ever state, what, you got a girl at home, you're out here trying to get some head?
What I asked him was, he indicated he was on the phone with this girl, and I said to him, do you want to be on the phone with your girl while we're talking to you about prostitution? Is what I said to him.
Okay. Stop calling me bro, did you make that statement to him? Why did you ask him to exit his vehicle?
Because he was erratic, he was moving around, flashing, I had no idea what he was doing, what he was about to do. He was very erratic.
Okay. And so when you asked him to step out, he complied, correct? Okay. And then, did you tell him at that point, hey, you're free to go if you want, you don't have to talk to me?
No, you're not talking.
Okay. So the lights were still on, correct?
Correct.
He's on the side of the road, I believe it's Woodward, Arizona, is that correct?
Dakota East.
I'm sorry?
Dakota East. of Woodward.
I'm sorry, Dakota East of Woodward. And how many, you're obviously a police officer, you had a badge on, correct?
Correct.
Had a gun?
Correct.
How many other officers were on the scene?
Two.
Two? And those officers each had badges and guns as well, correct? And you were all within eyesight of Mr. Johnson, is that correct?
Correct.
You agree with me, you were asking questions of Mr. Johnson, correct?
Correct.
And you were asking questions about crime that you alleged had occurred, namely prostitution?
Objection, this is asking him to this whole line of questioning. I've let it go on a long time, but he keeps asking the same questions because he doesn't really like the answers.
Actually, I didn't ask if he was trying to elicit statements. I was on the actual custody portion. I'm on the portion that he was just trying to elicit statements. I mean, it's yes or no, and I can move on.
Thank you, Jen. The officer has testified over and over about what the statements were, what he said, what the answers were, and what the questions were.
I'm going to allow it because it was a different question. But I think,
Yes.
you know where you're going.
No,
Exactly. The question you just asked is not the same as before. But it's giving you two seconds.
correct. And I'll make it real simple.
Okay.
You agree with me that once you stopped Mr. Johnson, you were asking him questions about an alleged crime, correct?
I was asking questions about the young lady who was at the scene.
Okay. And that young lady you believed was a prostitute, correct?
But I know it's a prostitute.
You know it's a prostitute, okay.
Mr. Johnson, you have an opportunity to speak to your attorney.
No, I said, excuse me, I burped.
Oh, I thought you had a question.
I said, excuse me.
Sorry.
Judge, nothing further, thank you.
Okay. Any redirect?
Yes.
No, and-
investigation of this nature, would it be possible to conduct an investigation without asking questions?
No.
Why would that be impossible?
Want to know what's going on. It's just that you don't know what's going on, so you just ask a question to find out. If you know, again, just questions, you just investigate.
Right, exactly. Do you conduct an investigation before an arrest? Because do you have to get probable cause?
Absolutely.
And would it be possible to get probable cause without an investigation?
It was more physical, yes.
Okay, but in this situation, would there be?
No.
Okay, and, so you'd have to do this investigation to get to an arrest.
Correct.
And an arrest is when you would do a Mirandize the person, right? Do you not have to Mirandize the person during an investigation because you're simply just investigating?
Correct.
And would you ever be able to get to an arrest without an investigation?
Again, if it's something physical that happened in the
This situation?
No.
And then going back to if the defendant was in handcuffs or not, you were able to see defense exhibit A, correct?
Correct.
Do you see the defendant in handcuffs in this picture? How would you describe the defendant's appearance in this picture, his hands specifically?
Holding his hand behind his back.
And is it possible to hold your hands behind your back without being in handcuffs?
Yes, ma'am.
Do you typically place someone in handcuffs during an investigation?
No.
And do you conduct your investigations in a kind of a ritual nature, like you do the same thing over and over?
Yes.
And is there a reason why you conduct your investigations in the same nature every time?
So you don't make mistakes.
And does that applicant testify too?
Correct.
Nothing further, thank you. Or I'm sorry, I have one more question. Thank you. Did you, besides the defendant's statements, was there any other reasons that you wrote him a ticket for this offense, for prosecution? Did it factor in the area that he was in?
Not necessarily the fact of the area, just the fact that no prostitute is not supposed to be close to his vehicle.
And the known prostitute being in his vehicle, did that factor in also?
Yes.
Nothing further, thank you.
Nothing for defense judge.
Thank you.
Thank you.
We're ready for argument when you are.
Oh, yep, that was it.
Okay. I don't know.
I'm sorry, I did not tell the court. Yeah, the people rest, that was my only witness.
Okay. And,
The defense will rest and proceed to argument.
okay. Whenever you are ready.
It is very clear from the corporal's testimony that there was no violations of a Miranda here. The defendant was not under arrest. That is why he was not Mirandized. There's a process of how you do this. You first have to see the make the stop, which happened. Then the investigation occurred, which is simply a pre-arrest thing. And also, an investigation does not have to lead to an arrest, but an arrest has to include an investigation. And here we didn't have an arrest. The defendant was, or the officer was simply investigating what was going on because of the area they were in, the defendant being with a known prostitute, and his behavior. The defendant's behavior is very erratic, and that stuck out in the corporal's memory, and that's why the investigation had to happen. And the defendant could have left at any time. He was not under arrest. That is why he wasn't Mirandized. And his statements that were made to the officer were free and voluntary from the situation that was going on, and no violations happened here regarding Miranda because this was simply an investigation. Officers have to be allowed to investigate without arresting, because if you had to jump right to an arrest, it'd make bad arrests. You have to have probable cause, which you have to get through an investigation. And here it was simply an investigation. The statements that were made from the defendant to the officer were free and voluntarily given. Miranda did not need to be given here. So the defendant's motion should be denied because the defendant was not under arrest and Miranda did not need to happen. These are good statements and we can continue on with the trial. Thank you.
Judge, from our perspective, let's be clear. Custody plus interrogation equals Miranda. I think the people are confusing, while an arrest is always certainly custody, most likely, arrest is not required to have somebody in a custodial environment. The officer agreed that he detained my client. He pulled him over, he used his lights, he asked him to step out of the vehicle, he had a gun, he had a badge on, there were two other officers, they brought another female to the scene, and I'm sorry, Judge, but he was free to leave, he could flee at any time. It's so unbelievably ridiculous that this officer actually testified to. Obviously, if the question isn't what the officer will say when he testifies if somebody's free to leave. It's a question of what would a reasonable person in Mr. Johnson's position believe that he was free to leave or not. The officer testified he did not tell Mr. Johnson he was free to leave. The officer did testify he pulled him over. He approached the car. He controlled his movements. He asked him to step out. He was asking him questions. He was not free to leave, and that testimony itself, Judge, is just so unbelievable. The officer even testified, yeah, if you put your lights on, people are free to leave, they haven't committed a crime. I mean, it's just beyond comprehension that an officer could actually testify that way in that manner. However, back to the issue is we have Miranda. Let me back up. The people have argued that the police cannot move directly to an arrest, and I agree. There has to be some type of investigation. However, when we have an investigation, mainly questioning, and somebody's in a custodial environment, that's fine not to move right to arrest. We just require officers to provide Miranda warnings to any particular suspect. Miranda versus Arizona stands for the proposition that custodial interrogation is questioning initiated by law enforcement officials after a person has been taken into custody or deprived of his or her freedom of action in any significant way. When you're pulled over, this wasn't a mere traffic stop like potentially the Berkemer versus McCarty decision. This wasn't just a routine stop. Oh, I'm going to investigate further. This is an officer who testified he knew why he was stopping the vehicle, was for investigation, was not for traffic, based upon his prior knowledge of who the other female was in the car, and that Mr. Johnson was pulled out, he was asked to step out of the motor vehicle, and he did so. Mr. Johnson stuck around. As you can see from Defendant's Exhibit A, Mr. Johnson, there's a picture with him and another female. He's obviously staying there, but at no point in time is he told he could leave. I would suspect, Judge, if he did try to take off on foot, there would be a pursuit and arrest for resist obstruct. We see that every day. So I just think that portion is unbelievable. The court is not required to take the officer's opinion of when Miranda is required, and the court is not required to basically give him deferential judgment as to when he is supposed to give him Mirandize. And I also think that you don't have to give any credibility to the fact that somebody who's pulled over by the police can just simply leave because they're not under arrest. I think because of that, Judge, Mr. Johnson was significantly deprived of his freedom, and in this case, Miranda was required. If the officer just given Miranda, we wouldn't be here for this issue, and we would be moving on. But Judge, we don't have that here, and because Miranda was not given by the officer to Mr. Johnson, any statements made from the investigatory stop forward should be suppressed. And I should say, any statements of Mr. Johnson. Thank you, Judge.
Thank you. I agree with counsel. The court does not need to follow the officer's opinion, but the court needs to follow the law. And the law states that in an investigation, Miranda does not need to be given. If Miranda needed to be given in all investigations, there'd be very little difference between an investigation and an arrest, and it would lead to bad arrests. This was simply an investigation. Officers need to be allowed to investigate. And in this situation, the officer testified that he could not investigate this particular crime without talking to the defendant. This is how the investigation was done and had to be done, was through verbal questions. And it was simply an investigation. Once again, I know I'm very repetitive, but that's the crux of this. This was an investigation, and Miranda did not need to be given because it did not rise to an arrest. That is the difference between an investigation and an arrest. We are simply in an investigation here, and these statements were voluntarily given. The defendant did not have to answer. And also, officers do not have to tell the defendant he can leave. He was in their presence, and they were doing an investigation. These were voluntary, good statements that were done without Miranda being needed. Thank you.
After hearing testimony and arguments from both parties, as you have both stated, the relevant case laws under People v. Miranda and People v. Walker. For the court, in determining voluntariness, the following circumstances have to be considered: the physical and mental state of the defendant, the length and conditions of detention, the age, mentality, and prior criminal experience of the defendant, the nature of any inducement offered, the conduct of the police, and the adequacy and frequency of the advice of rights. And that would be if the advice of rights was supposed to be given at the time. Corporal Landrum testified, and in my opinion, was very credible as far as his knowledge. He did not, in my opinion, lie about anything. I was not sure, based off of the exhibit here, whether Mr. Johnson was handcuffed or not. And looking at exhibit A, it could go both ways. Whether he was handcuffed or not, we won't know from today. His hands are behind his back. But there are other factors that come into play that, in my opinion, determine whether a person is free to leave the police. And I'm going to inject my own experience. This last week, I was pulled over by the police, and I don't believe I did anything wrong. And it came out that I did not do anything wrong. I was pulled over, the lights and sirens were on. I was just heading to a nail appointment. And at that time, if I didn't think I could do anything wrong, and I drove off, I do believe, and I think the reasonable person would believe that if you sped off or left while an officer was getting out of the vehicle with the lights on and approaching your vehicle, you would be pursued. With the lights being stopped, having to step out of the vehicle, and Corporal Landrum did say Mr. Johnson was erratic, and that made him cautious because he may have been moving his hands or reaching for things. And we know that officer safety is just important as those who are stopped. There were two other officers. Everyone had weapons on them. I disagree with the people that the reasonable person could think that he could leave at this time. This is a tricky one because officers do have to investigate to get to probable cause sometimes. That's not always the case. But my issue here is that when he was asked to step out of the car and that there were other officers around, I do not believe Mr. Johnson believed that he could freely walk away, and then at that point, he was in cuffs. We don't know if he was in handcuffs or not, if he was required to stand behind the vehicle with his hands behind his back. And I don't believe he was free to leave. The testimony was very important to determine whether or not Mr. Johnson just blurted out those statements about the $8 on his own, which would be a different story, or versus Corporal Landrum asking him those questions about whether or not he offered Ms. Lloyd any money. And from the testimony is my understanding that he was questioned, and when he even began to make statements, at no point did Corporal Landrum even invoke Miranda to at least stop him while he was giving statements about what he was doing, and admitting or making a confession, whatever you want to call it. I don't think also that we can say what Corporal Landrum would have done had he drove off. That would be, in my opinion, speculation. We don't know what people would do. I don't know what I would do if I was stopped with 3 people with guns and I didn't do anything, or if I did do something. I don't know what I would do. As I didn't do anything when the officer stopped me for something I didn't do. I sat there and waited to figure out why he stopped me. He told me why he stopped me. He didn't have to ask me any questions. So based off of the testimony today, I do not think that his statements were voluntary. And using the factors that I previously stated, I don't think Mr. Johnson was free to leave at any point until they said he was free to leave. His physical and mental state, he seemed, as Corporal Landrum said, nervous, erratic. And although the conduct of the police seemed very respectful, I don't think that they triggered or they began to Mirandize him, and they never did, after making an initial statement, after they questioned him about what he was doing. At no point did they ever Mirandize him, and he continued to talk. So I am going to grant defense counsel's motion and suppress the statements that he made regarding why or what he did when he picked up Ms. Lloyd in the vehicle. Which I didn't get all of it, it's not necessary, but I'm going to suppress that statement moving forward.
Judge, in light of that, and we thank you for your ruling on that, we obviously, motion number 2 becomes a moot point, so there'd be no reason to argue that. Judge, just for purposes of the record, I don't know what the court schedule is regarding trial. I'm due actually right now on that conference call, with the appearance with the Redford District Court, so I'm not sure if we wanted to try to fit in the trial today, or if you wanted to schedule for a different day. I know Ms. Rogers has to leave by 2.
I do have to leave by 2. It actually might work out well that you have a conference call. If I can please talk to the officers, my supervisor, how we want to proceed.
Okay, I'll be here.
Excellent.
Do you want me to call Redford and let them know what you were doing?
I'm going to zoom right in the next room.
Okay,
I'll let them know.
okay.
The chances are, Judge, they're not ready for me anyway.
That's
My experience there.
Mr. Johnson,
Yes, ma'am.
once you get done talking to your attorney, Warren, you can have a seat out in the hallway. We use the restroom, get some water, and then we'll let you know if we're gonna finish the trial today, or start the trial today, or if we're gonna do it a different day, okay?
So you not gonna stay around?
Yeah, stay in the hall and then we'll come out and get you, okay?
Don't leave, we're not done.
I ain't going nowhere. I ain't got nowhere to go.
He said, just so you're aware, if you get one, or today.